Yes, Mr. Larkin.
Well, as before the short adjournment, I said that I would draw attention to a sentencing authority where one sees how the licence is worked, and that's R against KT, EF 1851. And this was a Director of Public Prosecution's reference to the Court of Appeal. And one finds at paragraph 63, again on 1851, the conclusion that the overall sentence should be 3 years. Then under the heading the licence period, there's a discussion in 64 and 65. And in 65 in particular, there's reference to the particular circumstances of this offender. At the letter J, high priority for supervision and intervention, and that a period of 2 years on licence is required to ensure completion of that work. We consider that in all the circumstances, 2 years offence-focused work will assist in protecting the public from harm from the offender and will assist in preventing commission of further offences. We set the licence period of 2 years in order to facilitate this work. So an example of where the breakdown is 2/3, 1/3 licence custodial term. And at the last sentence in paragraph 64, one sees the citation of further authority in relation to the licence period. And I mention that because the suggestion appears to have emerged in the course of exchanges this morning that in some way what the judge does under Article 8 isn't really part of the sentencing exercise, that his delineation of the licence period and the custodial term in some way isn't part of the penalty.
Well, that's the Crown's submission.
Yes. And we said that it plainly resort to the pantomime, oh yes it is. It's clear that this is not the situation that my Lord Reid referred to in France, or indeed as we saw in Spain in Del Rio Prado, where a separate judiciary is involved in assessing remission. This is a task engaged in by the sentencing judge. And it can be readily analogized, we say, to the setting of a tariff in a discretionary life sentence case. There is a licence period thereafter. There's no dispute about that. But the delineation of the period in custody, and as I've emphasised, that which matters most as a matter of practicality and in terms of liberty to the prisoner, is worked out pursuant to the provisions of Article 8, and with reference, specific reference, because it's done indirectly, as we've seen by looking at 8.5 through by deciding what the licence period is going to be. And in KT, we saw an example of someone who is a difficult prisoner who has reoffended quite a bit and who therefore needs, in the view of the Court of Appeal, a licence period that amounts in fact to 2/3 of the total pronounced term. There was a suggestion in some way that the exercise of making an assessment of risk is not something which is central to the contemporary sentencing function. We say that's not right. One finds reference elsewhere.
Just before we leave this, it would be fair to say that the last sentence of paragraph 64 and the whole of paragraph 65 are concerned with issues of risk.
Yes, yes they are. Yeah, respectfully agree, my Lord. And that again is in the context of Article 8.5. We see elsewhere within the 2008 order, if we look at the 2008 order in its original form and go to Article 12, EF 522. We see the meaning of specified offences, and they're defined for the purpose of this chapter, specified sexual offence or specified terrorist offence, and they are done by reference to specified terrorism offence. It means an offence specified in Part 3 of Schedule 2. We don't have Schedule 2 in the bundle, but at the time of the sentencing exercise that Mr. Justice Colton engaged in, the offence that Mr. Morgan faced was simply an offence of membership. It wasn't an offence specified in Schedule 2 of the 2008 order at that time, but the additional offence faced by Mr. Marks, that of attending instruction in terrorism under Section 54 of the Terrorism Act, was. And we see that because the judge then goes on to consider whether or not he should do something about that. And we see that in core bundle.
Sorry, just before we leave this, this is the original form of the 2008 order.
Yes.
For what purpose are various offences being specified?
For the purposes of either imposing an indeterminate sentence or an extended sentence. And I'll take the court to those provisions.
Yes, sorry, thank you.
So I was just to flesh out the point so that the court can actually see a worked example of this. In paragraph 374, EF 452, this is with respect to Mr. Marks. Because the defendant has been convicted of an offence under Section 54(2) of the Terrorism Act 2000, I must consider the question of dangerousness under the 2008 order. I apply the same principles in my consideration of this issue as set out in detail in the case of Blair, who was the first to be dealt with on the indictment. And again, I'm quite sure the court has seen that, but the court may wish to look at that. There's a further, more fuller consideration of that with respect to Mr. Blair. And we see the conclusion in 376.
And just so that I can follow this, the question of dangerousness is relevant to whether there's an extended sentence being imposed.
Yes.
Okay.
And we see the conclusion in 376. Now, the court may wish to look overleaf to see the reasoning. I don't propose.
I apologise for interrupting. What's the relevance then of it being a specified offence? The judge excluded dangerousness.
Yes.
He then decides to impose a determinate custodial sentence.
Yes.
What's the relevance of being a specified offence?
That he had open to him findings as to dangerousness and either making an indeterminate sentence or an extended sentence. He took neither of those courses for the reasons that appear in the following page.
But how does that bear on the question?
Well, it's extent that there was a deliberate choice by the judge to rule out a sentencing option, and that judicial discretion has simply been overtaken by the legislature. The legislature has superimposed its will in the sentencing process, despite the judge having made findings which would have reached more or less the same outcome, and indeed arguably a more serious outcome.
But if the judge had imposed an extended sentence, that would be a sentence in the fuller sense of the word.
Yes. But what he did do, he considered, as he was bound to do, the option and rejected it as part of his proper judicial discretion. Now,
I don't recollect it being a part of the skeleton arguments or the statements of case at this point.
No, but I mentioned this simply because the issue has arisen as to whether or not this is a sentencing exercise at all. And the court has obviously looked at the entire ruling of Mr. Justice Colton, and we simply make the point that when one looks at it, there is no way in which Article 8 can be ring-fenced to some kind of separate abstract exercise. It is front and centre and an intrinsic part of the sentencing exercise. And I won't take the court to it simply because I'm...
Just so I could fully understand the point, Mr. Larkin, you're not suggesting that in some way the legislation has imposed an extended or indeterminate sentence?
No, certainly not an indeterminate sentence, but it has fundamentally adjusted the nature of the sentence imposed by Mr. Justice Colton.
Well, I mean, the way you put it, it rather begs the question. His choice of the sentence of imprisonment to impose is something that he reaches before he considers how he's going to apply Article 8.5, isn't it?
Well, perhaps maybe at this point to, and we're moving between materials for which I apologise, but it's important perhaps to see what the judge actually did in this case, and then see the legal framework which he doesn't fully recite there. So I've taken the court to Article 12, and the court has to consider, we can pass over Article 13 fairly swiftly and look at Article 14, which is EF 526. And this article applies where a person is convicted on indictment of a specified offence. That applies to Mr. Marks. And again, I asked the court to note the rather different approach that the legislature took in 2019, because committed after the commencement of this article. So one sees we say, an entirely convention-compliant approach. It's never been suggested, certainly not for one moment by us, that Parliament can't change sentencing policy, can't respond to terrorist threats as and when they arise. But it's got to act in a convention-compliant way, and that means that it can't act retrospectively. Quite apart from anything else, the common law has an intrinsic horror of retroactivity, articulated firmly by the Privy Council in Chandler.
But obviously, on any view, on either approach to this case, an extended sentence, the introduction of extended sentences altered the law in relation to sentencing. Because the court was imposing a longer, could impose
well, in fact,
a longer, well, it's just what it says, an extended sentence.
Well, the heading is interesting because, in fact, the custodial sentence is not the bit that's extended. So, if one looks at 14.4. In paragraph 3a, the appropriate custodial term means a term not exceeding the maximum term, which is the term that would, apart from this article, be imposed in compliance with Article 7, length of custodial sentences.
But surely it is the custodial sentence which is extended. I mean, 14.2 says the court shall impose on the offender an extended custodial sentence. It's calculated in a particular way, but what is imposed is a custodial sentence in the fullest sense of the word.
Well, no, it's not. Oddly, because if one looks at 3, so where the offender is aged 21 or over, an extended custodial sentence is a sentence of imprisonment, the term of which is equal to the aggregate of the appropriate custodial term and a further period, the extension period, for which the offender is to be subject to a licence.
Yes, well, as you've just read out, it's a sentence of imprisonment, the term of which is the aggregate of something called a custodial term and something called the extension period. So the term of imprisonment includes the extension period. It's envisaged that the person will be released on licence, but he is liable to be recalled to serve that period in custody.
Yes. But he is released. But the term, if one compares the sentence imposed under Articles 7 and 8 and one imposed under 7, 12 and 14, the Article 7 element is the same. The difference is that in Article 8 there is a reduction because the prisoner only serves within the pronounced term under Article 7 the term of the custodial period, whereas under Article 14 he serves the entirety of the pronounced term and in addition a period on licence.
So what?
Well, the concept is that the sentence applies to all of that. In fact, it's described in the heading as an extended custodial sentence. And
It's the exercise. The judge has got to start off with the concept of whether the offender is dangerous. He's got to start with that concept,
yes.
and he ruled it out.
Yes.
And he then moves on to a determinate custodial sentence.
And in Mr. Mark's case, the judge concluded that he was not dangerous in that sense.
In all the respondents' cases, he ruled they weren't dangerous.
Yes.
I mean, if one goes back, I mean, I think it's all coherent. If you, in Article 7, we're dealing with length of custodial sentences, we're told that subject to Article 14, the sentence shall be for such term as, in the opinion of the court, is commensurate with the seriousness of the offence. So that's subject to Article 14, where the sentence is for an extended term.
Yes, Lord.
So,
but we see in Article 14 that in fact
the whole of the extended sentence is a sentence. How is it put? Well, it's a sentence of imprisonment.
yes, again, our point is simply one is dealing in these judicial evaluations. One is dealing classically with sentencing exercise, and therefore it's simply not that one is exercising some sort of differentiated, tiny discretion. To use the description
I don't think there's
of an old friend.
There's no doubt about the fact that in deciding to impose a determinate custodial sentence, the judge is exercising a discretion. He's got to go through under B2, first of all, whether it's to impose a life sentence, and then an indeterminate custodial sentence,
yes.
and thereafter an extended custodial
Yes.
sentence,
Yes.
and finally
Yes.
a determinate custodial
With
sentence.
respect to a specified offence. And we make the additional point now that the nature of both of the relevant offences for Mr. Marks, Mr. Morgan, the Section 11 offence, the Section 54 offence, have now been given a different character because it is their inclusion in the new Schedule 2A of the amended 2008 order that lets this happen. And I'll simply give the court the page references to that. So we find the new Schedule 2A, paragraph 2, which deals with the Section 54 offence at EF 681, and then the membership offence, Section 11, is in paragraph 29A, and it's at EF 711. And of course, they couldn't partake of the Schedule 2A quality until this legislation was enacted in 2021, but it was given retrospective effect. In many ways, one of the key issues between the parties in the case is the effect of CAN. There are criticisms that may be made of CAN, but it is possible for the respondents to succeed entirely, and the court remain of the view that CAN is entirely good law, and good law in convention terms. Can I invite the court to turn up CAN and to look at the what is described by the Division Court as the fundamental question, EF 1039 in paragraph 86. And the fundamental question say the Divisional Court in Cannes is, what is the penalty? Is it the sentence imposed by the sentencing court, or is it the sentence ameliorated by whatever provisions are then in force for early release? And we're content with that question, and we said if that question is asked in this case, then what is plainly at issue is the sentence imposed by Mr. Justice Colton. And in putting the question that way, the Divisional Court, in fact, is responding to a fundamental theme of the relevant Strasbourg jurisprudence. So if we start with Utley at 1184, bottom of the page, as the sole penalties applied were those imposed by the sentencing judge, no heavier penalty was applied than the one applicable when the sentences were committed. And if we go to Galliano Peñas at EF 1164,
so what do we take out of 1184?
The court's reliance on the fairly fundamental point that the sentence imposed by the sentencing judge hadn't changed. So from Utley, I invite the court to look at Galliano Peñas at...
Why does that matter in the context of Utley? Because Article 7 looks at the penalty in place when the offence is committed, doesn't it?
Well, it looks...
And in this case, there had been a change in the licence or release regime between the date when the offence was committed and when the defendant was sentenced by the judge. So if Article 7 is concerned with the legal position at the time when the offence is committed, what point are you getting out of that last sentence on page 1184?
Well, I'm drawing attention to the fact that importance is placed on the actual sentencing disposition that took place when the applicant in that case was originally sentenced, and the court's drawing significance from. But
forgive me, isn't the significance being drawn here that the sentence imposed by the sentencing judge was within the bounds of sentence declared as possible at the time when the offence was committed?
No, it's saying that not that it was within the permissible range. What the court's saying there, and we see this is the enduring theme as we go through these, that the sentence itself hadn't changed.
But I mean, I'm just looking at this sentence. It says, as the sole penalties applied for those imposed by the sentencing judge, no heavier penalty was applied than the one applicable when the offences were committed. So.
No, but as were those imposed. So I place emphasis on the part of the sentence before the comma.
No, I know you do, but it's a question of what significance one attaches to that point being made. Well, let me put my question to you, and then you can do it. Isn't the point being made by the court here that this is a case where penalties have been imposed by the judge, obviously after the offence was committed, so not at the relevant time for the purposes of Article 7, fixing what can be imposed, but the sentences which were imposed by the judge were acceptable in Article 7 terms by reference to the declared possible penalty when the offence was committed, which is what Article 7 is concerned with. So isn't that the court just saying, well, the only penalty we're dealing with in this case is something that was imposed by the judge, admittedly a long time after the offences were committed, but was acceptable in Article 7 terms, judged by reference to the law at the time the offences were committed?
No, because as my Lord invites a closer reading of the sentence,
Yes.
one has to say that it's not as happily expressed as it might be. But it seems to me that if it were desired simply to say it was within the realm of possible sentences that were available at that time, we would have chosen rather different language to express that specific thought, whereas what's actually said before the comma is nothing happened to this man that hadn't been done by the trial judge, by the sentencing judge.
Yeah, sorry.
I hope that becomes clear when one looks through a succession of similar references within the Strasbourg cases. So one sees it possibly clearer in Galliano Peñas at 1164, paragraph 56. And this was a case about extension of the relevant limitation period, and the sentence beginning, despite being executed over 5 years after the sentencing, the penalty imposed on the applicant was not heavier than the one imposed at the material time. Hence, the change of the regulation of the interruption of the execution of the penalty's prescription period cannot be considered a change in the penalty applied to the applicant. So the penalty imposed on the applicant was not heavier than the one imposed at the material time. Now, that's, in its context, rather more happily expressed, and it isolates the importance, we say, of the sentence imposed by the trial judge at the relevant time. And in Abedin at 1094, at paragraph 36, having considered de Rio Prado, the same considerations do not apply to the present case. The applicant's penalty of 20 years imprisonment has not been changed, and it is to that penalty that the early release provisions continue to apply. There has been no conceivable redefinition or modification of the penalty imposed on the applicant, and the quotation marks around penalty, of course, to reflect the fact that, again, as we've seen, penalty has an autonomous convention meaning. And if we look at then, finally for this exercise, at Hogben at 1175, the top of the page, and then a reference to the eligibility for release. Although this may give rise to the result that his imprisonment is effectively harsher than if he had been eligible for release and parole at an earlier stage, such matters relate to the execution of the sentence as opposed to the penalty, which remains that of life imprisonment. Accordingly, it cannot be said that the penalty imposed is a heavier one than that imposed by the trial judge. And if one steps back a little, it is obvious that the penalty imposed on these applicants is in some cases heavier than that imposed by the trial judge. And
that depends on whether you define the penalty as the determinate custodial sentence or whether you define it as the custodial period.
Well,
and if it's the overall sentence, then it remains exactly the same.
Well, that's why it's helpful to look, perhaps again, at the warrant and its amendment, core volume 470. So originally, the court ordered on 13th November 2020 that the said defendant be committed to custody for the period of DCS 3 years, being 18 months imprisonment and 18 months on licence. That is if we don't have the Crown Court order, we have the warrant, on which obviously the prison service will have relied. But the warrant is a faithful reproduction of what we see relevant to Mr. Morgan in the judgment, the sentencing judgment of Mr. Justice Colton. It's clear there, we say, that the 3 months imprisonment, and there should be no great difficulty with this, is plainly part of the sentence. Indeed, when one goes over the page and sees the amendment, and in the paragraph beginning following the commencement of Article 30 of the Counter-Terrorism and Sentencing Act 2021, the above sentence, again referring compendiously to what's preceded it, was amended to reflect the revised mandatory custodial period set out in the statute, and was amended to, again, it's common case that the court, although the warrant recites an order by the court had nothing whatsoever to do with that, and I hazard the court will never have seen, indeed, this amended warrant. But the amendment refers to the sentence compendiously, and although a rather dubious document, in so referring, we say it's right to take that course.
In construing Article 8 of the 2008 order, presumably one looks to that rather than looking to a committal warrant drawn up by somebody else. Well, true construction, the true interpretation of the statutory provision must depend upon looking at the statute.
Yes, and of course I won't leave the amended warrant without pointing out, of course, that the amended warrant is still inaccurate, because it would give the prisoner, or the prison officials to whom it's primarily addressed, the impression that at the end of the amended custodial period he's released. Of course he's not. That's a matter for the parole commissioners. In a sense, we spent a bit of time looking at some of the other provisions in the 2008 order, other sentencing options, one which was open to the court in Mr. Mark's case, wasn't then open to the court in Mr. Morgan's case, and the particular dispositions that occurred. And all of that for the purpose of emphasising that what one is dealing with here is a sentencing exercise. And we find that also, I suppose, fine in this context if we go back to Can. Because if you go back to Can, EF 1045, top of the page, EF 1045, paragraph 105. In the present case, the changes wrought by the 2020 Act were changes in the arrangements for early release. They were not changes to the sentence imposed by the sentencing judge. And in a sense, that's right in the English context, because what is being dealt with there is the statutory automatic, and quite literally automatic, rule where one is simply released at the halfway point. And simply for the court's note, I won't invite the court to look at it now, but at EF 759, one has section 244 of the 2003 Criminal Justice Act, where there is the duty to release prisoners not subject to special provision for release at the halfway point. One could pause there and reflect for a moment on the profound distinction we say that exists between the regime under Article 8 and the regime under Section 244 by asking this: would it be possible for someone to enter a criminal appeal with respect to the phenomenon contained in Section 244? Of course, the answer is no, they couldn't. But if someone was unhappy with the licence period, the custodial period, that could be the subject of an application for permission to appeal to the Northern Ireland Court of Appeal. Now, it happened in a different way, of course. In the KT case, it was a director's reference, but nonetheless, the licence period was subject to considerable adjustment by the court.
In relation to Section 244, this seems to be a default provision which applies to prisoners unless they're subject to special provision for release. And the default seems to be automatic release on licence.
Yes.
And are we dealing with prisoners to whom special provisions apply?
Well, this doesn't apply in Northern Ireland, so this is...
Oh, I'm sorry.
I'm sorry, my lord.
No, it's my fault.
It's my fault. I should have been much clearer. This is our comparator. So,
I see.
So this is the provision that applied in Cannes. Hence, the Divisional Court were absolutely right to say that the order itself remained unaffected. What was changed was the period contained in Section 244.
So to understand, the default position in Northern Ireland is different?
Yeah, well, there is, in truth, no default position because it doesn't happen by itself. Under Article 8, the period arrived at is the product of judicial determination.
Well, there used to be a default position until the 2008 order.
Yes.
There was 50% remission, after which you were released from custody without any licence conditions at all and were free to do whatever you wanted to do. That still exists, as I understand it, in relation to sentences for less than 12 months. And the automatic remission, 50% remission, doesn't now apply at all to any other sentence in Northern Ireland. And it applies automatically to every determinate custodial sentence in England and Wales.
Yes.
And
well, does it?
apart from the exceptions.
This isn't remission, is it?
No, it's not remission. No. But that's the learned friend, Dr. Gleelan, referred to the presence of a remission regime on the Northern Ireland Statute Book. We've just heard the reason for it because it still operates with respect to sentences of less.
So in relation to sentences of 12 months or more, there's no remission. Yes. There's an early release regime. Yes. We've seen that the judge has a role in that under Article 8.
Yes.
And once the license, or once the custodial term or period has been served, is release then automatic?
It is. It's not an expectation, it's a right to release. And that's why, I won't take the court...
So the role of a parole commission, is that only in relation to longer term prisoners or consideration of recall on license?
Under the old regime, only in relation to recall. But now, unlike the amended warrant, one doesn't get out immediately post the 2/3 period. One has to satisfy the parole commissioners.
Yeah.
Right, but before the changes, what would be the licence conditions? Were they laid down?
There's provision for them in the 2008 order. We don't have a copy of their standard conditions, and we don't have a copy in the papers of standard conditions.
Licence conditions are set by the Department of Justice,
yes.
And but the judge can recommend various conditions to impose.
Yes.
And the Department of Justice has an obligation to take those recommendations into consideration.
So you say it's a right of appeal from an Article 8 determination?
Yes.
Where do we see that?
Well, it forms part of the order of the court, and under Section 10 of the Criminal Appeal Northern Ireland Act, one can appeal the sentence imposed of which that is a part. And we have a worked example, albeit the other way, because it's a reference by the Director of Public Prosecutions, which then leads the Northern Ireland Court of Appeal. That's the KT case that I've just recently shown the court.
I suppose one can imagine situations. I can't presently think of an example of such an appeal, but if the appellant, the offender, was content that the overall sentence was appropriate, but the license period, but if something fundamentally had gone wrong with fixing the license period and therefore the custodial period, your point is that they have a right of appeal to the Court of Appeal, demonstrating that it's a part of the penalty.
And we had tested by almost imagining if if, for example, the offender in KT had received 3 years at first instance, but contrary to what was obviously the recommendation of probation on appeal, that he have 2 years to complete a prescribed course of work, he'd be given 12 months without any particular reason for that, or rather, 3 years, 18 months without any particular reason, then one could readily see an appeal to the Court of Appeal not arguing with the top line figure, but saying, look, the proper approach is to ensure that I have this opportunity to do the work, and I need the 2 years for that.
Yeah. Or alternatively, if the judge had gone wrong in totally rejecting the probation, the pre-sentence report, and had expressed invalid reasons for doing so.
Indeed. Respectfully agree, my Lord.
Do we have Section 10?
We do. And it's at EF 784.
The submission being put against you is that, or the main submission put against you, is that there's a clear and consistent line of Strasbourg jurisprudence and domestic jurisprudence that would indicate we have a clear distinction between the penalty and the execution or administration of that penalty. I think it's also said against you that release on licence is always part of the execution or administration of a sentence. Now, and it doesn't matter what form that release on licence might take, because one needs an autonomous meaning because of Strasbourg, the need for it to be applicable across many jurisdictions. So it doesn't actually matter on the submissions against you whether the judges are involved or not, as I understand the submission. So how are you answering what I would regard as the principal arguments? I mean, you're telling us the judges are very much involved.
Yes.
Okay. I don't think, in some senses, one can dispute that. The question is, what's the relevance of their involvement?
Well, I suppose the answer to that really isn't possibly three parts. Firstly, as my Lord has observed, there is a role for the judge, and it's precisely for that reason that I took the court to the four examples within the Strasbourg cases of where significance is attached to there having been no change in what the judge ordered. Here we're dealing fundamentally with a change in what the judge ordered. Secondly, it's a recurring theme, and it's certainly a theme of Del Rio Prado, that the distinction isn't always easy to observe. And the court, I won't take the court to it now, certainly not in detail, but the court may find profit in reading the dissent of Judge Mahoney, the UK judge, in Del Rio Prado, because in that dissent he says, actually, I know you say there is this distinction, but you've actually breached it fundamentally by finding a breach of Article 7 in this case. And Del Rio Prado, in fact, is a good example of, in one sense, where I'm in cautious agreement with Byrne and Friends, that it depends what the role of the judge is. And what may have given some strength to the position of Judge Mahoney was the fact, of course, that there had been judicial involvement post-sentence, but that there was a discrete role for a judge involved in the execution of penalties. And in one sense, one needn't be overly dazzled by the name, but the precise function of the judge was to deal with the execution of penalties. That was the judge who accorded the remission in the relevant case. So we're, in one sense, happy with the preservation of the distinction. We observe, Del Rio Prado may be an example of this, that the distinction hasn't always been maintained clearly. The court itself acknowledges that the line is sometimes hard to draw, but wherever one draws the line, whereas here one is dealing with an order, I won't use the sort of the self-referring term of sentence, but an order by a sentencing judge, and the order as a key component part sets out the term of imprisonment actually to be served, then being as realistic about it as we're enjoined to be, because as we're always told, the Strasbourg regime protection isn't designed to be illusory, it's designed to concretely protect rights, that any legislative increase in the custodial term pronounced by the judge offends Article 7.
I mean, the difficulty I have with that is that even in the English and Welsh system, the licensing provisions were a key component, or are a key component, of the sentence.
Well, they're as we know from Cannes, there's something with which the trial judge has nothing to do. And that's why, in a sense, it's no part of our function here to argue that Cannes was wrongly decided, and it may be interesting to see if there is an application to Strasbourg in that case, what comes of it. So we're content to bank Cannes and say that if one applies Cannes, we're not dealing in Northern Ireland with a legislatively imposed release period. We're dealing with the product of judicial evaluation.
And if you go back to page 784 and section 10, subsection 3 states that the Court of Appeal can quash the sentence passed by the Crown Court and pass such other sentence authorised by law.
Yes.
And in KT, I assume that's what we did.
Yes, exactly so.
And that included the licence period.
Yes, it did. It did.
Well, they would be bound to if one. I don't think one can infer from that the sentence was taken as including the licence period, or indeed that you could appeal under Section 8 against the licence period that was selected. But it would follow if you appealed against the sentence of imprisonment imposed successfully, and the appeal court were sentencing you of new, they would be under the same duty under Article 8 to decide on a custodial period.
Well, they wouldn't be under the same duty under Article 8 because they might take the view, we think that the sentencing judge got it right, and therefore we're not engaging in a resentencing exercise.
Of course, but if they allowed the appeal,
Yes.
Either because they thought the sentence was too severe or because they thought it was unduly lenient,
Yes.
they would have to undertake a sentencing exercise,
Indeed.
and part of that would be, well, they'll have to do it in accordance with Article 8.
Yes. I suppose two points. Firstly, if one posits someone who is relatively content and acknowledges that perhaps the headline figure is just, but wishes to present a surgical appeal to the Court of Appeal in Northern Ireland, indeed we would hope that more of such appeals are brought. So, look, I don't have a problem with 3 years, but I do have a problem. I need help. Probation say they can give me help if I do this course for 2 years, but the judge, again, to use the examples of my Lord Lordship, doesn't give reasons, appears to ignore the probation report. Well, all of the things being equal, that's going to be a pretty good appeal. But more importantly, it's an appeal that can be made.
Well, you say that.
Yes.
Do you vouch that?
Yes. Well, it's a... unless it falls out with Section 8, so Section 8 is what confers the right of appeal at 782 against the sentence passed on his conviction. The question, is this part of the sentence passed on his conviction?
Exactly.
But it would be respectfully, a strained construction of Section 8 if in some way the evaluation that took place under Article 8 fell out of that. But this is useful because it shows that it has to fall out of it for the central contention of minority friends to be correct. That in some way,
well, I'm not sure. It's not critical because the notion of penalty for purposes of Article 7 is an autonomous concept.
Yes.
So it's not necessarily coterminous with sentence as used in this legislation.
But the other, again, one has to bear in mind that we're fortunate on this appeal in having an appeal from the Northern Ireland Court of Appeal exercising criminal jurisdiction, and the bread and butter of that court is dealing, among other things, with appeals against sentence. This was, as we've discussed, unusual in a number of respects. But I do commend the approach and the analysis of the Court of Appeal at EF 239 240 from paragraphs 89 to 94. And this is a provision, obviously, this court can take whatever view of the legislation that it considers proper, but here one has the worked system in Northern Ireland being evaluated by persons who are familiar with it on a day-to-day basis, and they have no difficulty in concluding that the sentence has been retrospectively reworked to the disadvantage of the then appellant.
But I mean, as Lord Reid pointed out, even if one construes the word sentence in Section 8 of the Criminal Appeals Act to include whatever is the product of the Article 8 process, that doesn't assist, does it, in determining whether the Article 8 process and the imposition of a licence constitutes penalty, the autonomous concept for the purposes of Article 7?
Yes. Well, I suppose there are two stages. I suggested that there would be something strained and artificial in construing Section 8 so as to leave out the Article 8 exercise from that definition of sentence. But equally, in convention terms, and bearing in mind that the convention approach to subsidiarity will not stop with the domestic classification, but our respectful suggestion is that Strasbourg would have no difficulty whatsoever in seeing what the judge does, what the sentencing judge does, under Article 8 as being part of the penalty for the purposes of Article 7 and indeed Article 5. Can I turn to a different topic? One of the issues where we're in respectful disagreement with the Court of Appeal is in their approach to foreseeability and equality of law. So if one looks at core EF 241, and from 96 to 102. 97, the introduction of the 2021 Act breaches the notion of quality of law requirements because of the alleged imposition of the new regime in respect of terrorist offenders out of the blue and without notice, and in circumstances in which the offender could not have foreseen them arising. And the case being made is not about accessibility or vagueness of language, neither of which seems apposite to the present facts. Well, it was and is partly about accessibility as well as quality of law, and the point can be swiftly made. And here one sees in the cases an overlap between Article 7 and Article 5, both of which insist on a certain quality of law in order that the necessary principle of legality be established. And I'll simply give the Court the reference quickly to Kafkaris. Kafkaris is often, the headline in Kafkaris is that the applicant fails to win on Article 7 in terms of retroactive penalty, but in fact he wins on quality of law. EF 2458, paragraph 153, and if we look at De Leo Prado, there the issue of Article 5, quality of law, is considered under Article 5. So if we start with paragraph 125, EF 1137. So, paragraph begins at 1136. It's well established in the Court's case law that all deprivation of liberty must only be based on one of the exceptions listed in subparas A to F, but must also be lawful. Whether lawfulness of detention is an issue, including the question whether a procedure prescribed by law has been followed, the Convention refers essentially to national law and lays down the obligation to conform to the substantive and procedural rules of national law. This primarily requires any arrest or detention to have a legal basis in domestic law, but also relates to the quality of the law, requiring it to be compatible with the rule of law, a concept inherent in all the articles of the Convention. The quality of the law implies that where a national law authorises deprivation of liberty, it must be sufficiently accessible, precise and foreseeable in its application to avoid all risk of arbitrariness. The standard of lawfulness set by the Convention requires that all law be sufficiently precise to allow the person, if need be with appropriate advice, to foresee to a degree that is reasonable in the circumstances the consequences which a given action may entail. Where deprivation of liberty is concerned, it is essential that domestic law define clearly the conditions for detention. Now, there's an element, of course, of the artificial, but nonetheless it's an important protection because one can't really imagine potential offenders evaluating in a mathematical sense risk-reward by reference to the possibility of the penalty retrospectively increasing. But not only this is a double Article 7 case and an Article 5 case in terms of quality of law, because we're not simply dealing with something that happened post-commission of offence. We're dealing with something that happened post-commission of offence, but also post-sentencing exercise when the law was changed. And
but I mean, if the penalty is the custodial sentence, there's no problem with the quality of law, is there?
well,
I mean, the law laid down what the maximum custodial sentence would be. The custodial sentence imposed was below that.
no, respectively, Lord, what one had was a sentence imposed by the trial judge. So there would have been advice, and then the sentence was imposed. There would have been advice then about what that meant. The effect of the judicial determination would be explained. And at that point, of course, if one asks, well, and is that what happened? Well, of course, one knows it didn't. And it's a pretty straightforward proposition. And the Court of Appeal didn't accept it, but we invite this court to do so. Simply this, that we're going to have a situation where the liberty of the citizen can be post hoc adjusted to the citizen's detriment by Act of Parliament. Then one is truly in a state of affairs where the law and liberty is not foreseeable, particularly when it happens, as we emphasise, in a doubly offensive way, not only after conviction, not only after the commission of the relevant offences, but after also within W. Prado, if one turns to 130 and at EF 1138, the court must examine whether the law authorising the applicant's continued detention beyond the 2nd of July 2008 was sufficiently foreseeable in its application. Compliance with the foreseeability requirement must be examined with regard to the law enforced at the time of the initial conviction and throughout the subsequent period of detention. Well, at the time of the initial conviction, of course, this was not the law of the land. It subsequently became it, and the judicial determination was unravelled in the way that we've seen. And that's why I did, in passing, refer to the distinction, because when changes took place in 2019 with respect to the indeterminate sentence and the extended sentence, they were made prospective. So dealing with persons who committed offences after the coming into force of that provision, and we say that was the entirely proper convention compliant approach. And since we have W. Prado open, can I invite the court to look also at paragraph 89, EF 1126. And then a passage that's been repeatedly quoted in the other cases, including most recently in Kapinski. In the light of the foregoing, the court does not rule out the possibility that measures taken by the legislature, the administrative authorities of the courts, after the final sentence has been imposed or while the sentence is being served, may result in the redefinition or modification of the scope of the penalty imposed by the trial court. And that is, we say this case plainly, when that happens, the court considers that the measures concerned should fall within the scope of the prohibition of the retroactive application of penalties enshrined in Article 7.1. Otherwise, states would be free, by amending the law or reinterpreting the established regulations, for example, to adopt measures which retroactively define the scope of the penalty imposed to the convicted person's detriment, when the latter could not have imagined such a development at the time when the offence was committed or the sentence was imposed. In such conditions, Article 7.1 would be deprived of any useful effect for convicted persons, the scope of whose sentences was changed ex post facto to their disadvantage. And we say that is classically this case.
But I mean, in paragraph 89, the court again is deploying the distinction it's already drawn between the scope of the penalty and then in the last sentence, the manner of execution.
Yes, respectfully agree. But that's why then one goes back to 1126/89, the redefinition or scope of the penalty imposed by the trial court, and that's the key concept here. This is not where there is some dispute about a prison governor allowing remission. There is no remission regime, or some separate judicial function with respect to totting up days worked, as indeed in Del Rio Prado, and that's why we do make the point that one might consider that there is force in Judge Mahoney's dissent, where he points all of this out, and what you're dealing with is something, the execution of the sentence. And even he, of course, finds that what happened to Ms. Del Rio Prado offended Article 5 in terms of the quality of law requirement. And if moving, and one can deal with this briefly, Article 5.1a. In Article 5.1a, there is the causation requirement, and that's made clear in paragraph 124 of Del Rio Prado at 1136. And that is the word after in subparagraph A doesn't simply mean that the detention must follow the conviction in point of time. In addition, the detention must follow and depend upon, or occur by virtue of the conviction. In short, there must be a sufficient causal connection between the two. And then it goes on about passage of time. The causal link might eventually be broken if a position was reached in which a decision not to release or to re-detain a person was based on grounds that were inconsistent with the objectives of the sentencing court, or on an assessment that was unreasonable in terms of those objectives. Well, the reference to the objectives of the sentencing court is important, because the court has certain objectives that it must address its mind to in the Article 8.5 evaluation, and those objectives are replaced by others, as we've seen in 20A. So the judge is engaged in a discrete sentencing task under 8.5. He discharges that function, resulting in the delineation of a custodial period. And then something else happens. There is legislative intervention. And if the question is asked, in the period between the elapse of the point set by the trial judge and the point at which Mr. Marks and Mr. Morgan are eventually released, is he in prison pursuant to the judicial order? The answer must come that he is not in prison pursuant to the judicial order. He's in prison pursuant to Act of Parliament. And in a sense, a clearer violation of Article 5.1a couldn't, we respectfully suggest, be imagined. If Your Lordship would give me...
Yes, of course.
Grateful to my learned friend. He reminds me of the importance of of paragraph 90 of Del Rio Prado, which is at EF 1127. And we commend the reasoning therein to the court.
I think it's. Well, speaking for myself, I don't find Del Rio Prado altogether easy to follow, and the concurring and dissenting judgments contain interesting discussions of the problems
Yes.
about the reasoning. One of the, I'm just going to see which judgment it is. One of the concurring judgments, Judge Nicolau,
Yes.
is quite interesting. He focuses on the fact that at the time that Ms. Del Rio Prado was sentenced, her sentence had to be treated as a sentence of 30 years for the purposes of then applying the early release scheme. And then as a result of the change in the jurisprudence of the Spanish Supreme Court, which of course had retrospective effect, as ours would,
Yes.
The sentence had to be taken to be one of 3,000 years
Yes.
for the purposes of early release. That is a change in what the sentence is being taken to be for the purposes of applying early release provisions. It's not simply a change to early. It's not simply a change to early release provisions themselves, but to what the sentence is taken to have been.
Yes, well, that's the value of 89 and 90, because one has to focus on what Mr. Justice Colton did, and I suppose it might be said that insofar as what one can, with hesitation, venture a judgment as to the quality of the reasoning of the Spanish courts, it does seem that there was a clear linguistic distinction, at least, between the sentences pronounced, which totaled 30 years, and then a concept that might bear some analogy to what's at play here, the maximum custodial term that could be imposed, and in Parrott, there was rather close linguistic analysis, and essentially this, well, it's off the sentence, and 30 years isn't a new sentence, so that means that it comes off the 3,000 odd year figure. But the point would be, and this was the reasoning, and I confess, so far as one can understand it, of Judge Nicolai, that essentially the sentence for him changed because it was 30 years with the possibility of discount, to 30 years with the possibility of no discount. But in many ways, this emphasises the importance.
I don't think that's quite how he's putting it. The problem was that the practical problem was that this woman expected that her good behaviour in prison would result in meaningful remission of sentence because the deduction was being made from a period of 30 years. Now, if she was entitled to the same amount of remission, but it's being deducted from 3,000 years, then it's of no benefit whatsoever. So that was a practical issue. And as an emphasis in the judgment, well, as one of the factors referred to as legitimate expectations, if you like. But as you say, what they're saying at 89 is that, paragraph 89, is that the court doesn't rule out the possibility that measures taken by, in this case, the courts, may result in the redefinition or modification of the scope of a penalty imposed by the trial court. And when that happens, Article 7.1 will apply. And if it seems to be the case, the effect of a change in the case law was to say we take the sentence to be one of 3,000 years rather than to be one of 30 years for the purpose of then applying the early release scheme to it, the remission scheme to it. Then the sentence is being treated as being something different from what it was at the time when it was imposed.
Yes. And we would say, well, that's what's happening here. It's the sentence is being retrospectively recast, and we submit with some brio, I suppose, that this is a better case than Del Rio Prado, because in Del Rio Prado, when the sentence is imposed, nothing in fact has been earned. The days worked ex hypothesi haven't occurred, so that's something which occurs, and it's administered again. Nothing, or at least not everything, turns on the name, but by a judge given a separate function of adjudicating that, and that's, one would have thought, classically within the scope of the execution of the sentence, and that's the matter of which Judge Mahoney complains. But this is a better case, we say, because it's all imposed by the trial judge, and then Parliament simply comes in. Nothing dependent on the conduct of the individual prisoner. This is something which he is entitled to as a matter of law following the relevant judicial determination. But there might be value, again, in thinking about how this is approached in Kapinski, because they use the 30-year model and say, well, the difference there was between 30 years with the possibility of meaningful reduction and 30 years with no meaningful possibility of reduction. But when one puts the matter that way, one sees that that's something which occurs after the event, has to be separately earned by the prisoner, and that's not the case here. In that sense, this is a stronger case. If the court has Kapinski to hand, one sees in paragraph 64 the court observes that the penalty that was applicable at the time the criminal offence was committed within the meaning of Article 7 was reducible life sentence. And I'm not sure how much turns on this, but that doesn't seem in fact to be correct, because if one looks at paragraph 24, which sets out the relevant provisions of Hungarian law, and to if a life sentence goes down to Article 40, capital A, if a life sentence is imposed, the court shall define in its judgment the earliest date of eligibility for parole, or it should exclude eligibility for parole. So the court, and one sees this elsewhere in the judgment, had the choice at that stage of either going for life sentence with eligibility for parole or one without. And the reason why we say that's important here is because it properly places the emphasis on what the trial judge actually did. And when one places the emphasis on what the trial judge actually did and what happened to his, I'll use the usual term, order, then we say that breaches of Articles 5 and 7 are pretty readily discerned. Very grateful to the court for questions that have enabled me, I hope, to illuminate our submission rather more rapidly than might otherwise have been the case. Subject to any questions for the court, those are our submissions.
Thank you. Thank you very much. Yes, it's MacDonald.
I was once told off by Lord Hoffman in his characteristically gentle manner for repeating, albeit more emphatically, the submissions that had already been made quite adequately, he said, by previous counsel. So I don't want to make the same mistake again. So I propose to confine my remarks to two, without prejudice to the written submissions we've already made.
Yes.
I propose to confine my remarks to two matters.
Yes.
First of all, the interpretative obligation, and secondly, if Article 20A can't be read down to the remedy, if that's not presumptuous. In relation to the interpretative obligation, there are two aspects to this. First of all, as the court knows, Section 3 of the Human Rights Act requires the court, as far as it is possible to do so, not just reasonable to do so, so far as it's possible to do so, to read and give effect to the legislation in a way that is compatible.
Isn't this an aspect of the cross appeal for which you didn't get leave?
It actually has a bearing on both Article 5 and Article 7, and I suppose to some extent I might need to refer to some of the facts in order to explain why I'm dealing with these matters, because...
So far as Article 7 is concerned, you've won so far.
We've got a declaration of incompatibility,
Quite.
which we say would be appropriate in circumstances where it can't be read down.
Right.
And the question remains still whether or not it could be read down.
Well, that's why I asked that. That would depend on a cross appeal, for which you don't have permission.
Yes, but the answer to the question is essentially that the court, and this could have raised the questions about the difference between form and substance here. The court itself is, of course, under an obligation by virtue of Section 6 of the Human Rights Act not to act in a manner that's incompatible with convention rights. And that in turn depends to some extent what the facts are in this case. And unlike the other respondents, Mr. Lynch is still in prison. Now, if he is released in accordance with the order of the court, the original court, then he will be released in 5 weeks' time. If he's not released in accordance with the order of the court, if the Article 20A provision is given the effect contended for by the appellant, then he will be detained in custody for another 13 months. And then the question arises whether the court is under a Section 6 obligation to do something about that, and perhaps do what the...
We've refused you permission to appeal on
Yes.
this ground. That's that.
Well, that's that if the court takes a narrow view of its own obligations under Section 6.
The matter has been decided.
Yes, and as a matter of form, that's right, but as a matter of substance, the question may remain, depending on the court's view of this legislation, the court may remain under an obligation to do something about the situation. Now, certainly in Del Rio Prado...
I have to say, I don't follow that. I mean, if the court's looked at your application for permission to appeal and refused it, that is compliance.
On a preliminary basis.
Well, no, on a final basis.
It's not a provisional decision.
Well, the court is now looking at the matter substantively, and if the court were to come to the view that this legislation can be read down, then the court would be under an obligation to do something about that state of affairs.
But that's not an issue before us on this appeal. The appeal before us is defined by the government's appeal and by the cross appeal on the limited grounds for which permission has been given, which does not include this.
If the court subordinates the substance to the form of the matter, to the procedure, then that would be technically correct. The question is whether or not, if the court...
I've heard enough about this. You better move on to your next point.
Well, the first point concerns interpretive obligations. If the court doesn't allow me to deal with that, then the second point is remedy,
Yep.
which arises from the interpretive obligation. And if the court thinks that remedy is not part of the appeal, is not prepared to allow me to deal with the matter, then I have no further submissions to make in addition to those that have already been made, and in addition to those that have already been made in our written submissions.
Is the point about remedy the one that was discussed with Mr. Larkin, with Mr. McGleenham this morning?
It was a slightly different one.
Well,
You were saying that the Court of Appeal had the opportunity or the power to adjust the overall sentence.
In the ordinary exercise of its appellate powers, yes, it would have done that. Obviously, an irregular, an unusual state of affairs, but entirely within its powers. And that remedy would be consistent with, as I say, the court's obligations under Section 6, depending on the view it takes of Article 20A, and it would correspond with the action recommended by Del Rio Prado.
But I mean, isn't that completely dependent on the point you were seeking to make about interpretative obligation? Indeed, you said the remedy runs with the interpretative obligation argument. So if you don't have permission to do that, I can't see you've got permission to argue remedy any further.
It largely does. As I say, if the court takes a strict, and if I can say so, respectfully rigid view of the scope of this appeal, then I'm not in a position to advance that matter.
No, well, we're not here to review decisions that have already been taken. prior to the hearing about the scope of the hearing. And this matter was dealt with by the panel that I think Lord Hodge presided in, that dealt with your application to bring these points on a cross appeal.
I'm not going to be argumentative about this, my Lord, but at the same time, I'm conscious that if the court were to form a view about the compatibility of this provision and whether or not it could be read down properly, then an issue would arise of what the remedy would be. And the only answer could be, well, nothing has been discussed about remedy.
No, I'm afraid we can't hear you on this, Mr. MacDonald.
As the court please.
I think that leaves you, Mr. Lavery.
Well, I'm going to take my steer from what's already been said.
Is your point really the same?
Well, it was, and that was dealt with in our submissions.
Yeah.
We have, and this is by way of background, I'm not going to ask the court to revisit the issue of remedy. In not doing that, I don't want to prejudge the outcome of the case in any way, but the court may be minded to make a declaration or it may not. In carrying out that exercise, the court will have to determine whether or not subordinate legislation or not. I leave the matter there, my lords. One point of background and how this arose, there were a judicial review application which was lodged prior to this criminal appeal which raised these issues, and the court will be aware from the chronology. I'm not going to go through it now. It went to Mr. Justice Schofield, then leave was refused, it went to the Court of Appeal. The Court of Appeal stayed pending the outcome of the judgment in this court. If this court were to uphold the Article 7 declaration, then that is something which can ultimately be dealt with if there's a remedy issue to be dealt with at that point as part of those judicial review proceedings.
Yeah.
I think that's all that I want to say, my lords, unless I can be of any. Of course, I adopt the submissions of my learned friend in relation to the principal point.
Yes, that's understood.
Yes.
Thank you very much, Ms. Lavery.
Thank you, my lords.
I think we return then to you, Sir James.
We do. I've got one tiny point, and then I know Mr. McLean is going to address you very briefly, if that's acceptable, on the appeal rights in Northern Ireland. My point relates to the submission made by Mr. Larkin that there are lots of examples in the case law that you have been shown of the courts, domestic and in Strasbourg, attaching significance to the fact that it was, as it were, judges involved at the sentencing at that point. It's that issue. And two in particular he placed reliance upon, one in the domestic courts and one in Strasbourg, which he said illustrated that proposition. The first of them is in the Khan case itself. And if you go back to it, if you would, just briefly, page 1045, and it's paragraph 105 for this purpose, and it's the reference to the sentencing judge in the third line. And the short and obvious point to make in relation to that sentence and its location within the judgment of the divisional court is that it is clear, even from the face of the first sentence read in isolation of 105, that what is being done is to draw a contrast between the sentence underlined, which was the determinate sentence, see previous analysis, as compared to the arrangements for early release, see the first part of the sentence. And that is in accordance, and absolutely in accordance, with the key features of the analysis that had preceded paragraph 105. So it isn't actually attaching any significance to the identity of the judge as being critical for, or the non-involvement, as it were, in the early release provisions as being critical for the purpose of Article 7. It's drawing a completely different contrast. There is nothing, therefore, in that paragraph that advances my learned friend's case. The other reference that he gave you, key reference that he gave you, was to the Utley case, at page 1184 in the electronic bundle. And we have two answers to that. The first one is to agree with my Lord Sales and his analysis of what the final sentence on that page is actually doing and the issue which it's actually addressing, which is not the issue for which my learned friend sought to deploy it. But in any event, and even if it's part of a broader analysis, it is simply, again, a bit like the position in Khan, recording the determinate sentence. There's not a suggestion that, that as it were, the involvement of a judge is critical or non-critical. That's just the way they expressed it. That was the answer I think I gave in substance to Lord Burrows when he asked me the question about that sentence earlier on. It's simply recording the fact rather than attaching legal significance to the point. So those two references we submit do not advance my learned friend's case at all. And I confess that we didn't understand that the reference to Galeano Peñas and Spain, which my learned friend referred to, paragraph 56 on page 1164, that doesn't do the job for him at all in any event, because there doesn't appear to be any reliance upon judge involvement at the sentencing stage at all in that case. So none of the three key references that my learned friend Mr. Larkin gave you as support for the core proposition which he sought to advance actually does advance that core proposition. The court may feel that the more significant feature of the submissions that you have heard from the respondents to this appeal is that not a single one of them at any point has addressed any part of the argument of principle that we advanced in opening this appeal as to why it would be, as to why the position plainly was not in either Strasbourg or in the domestic jurisprudence to attach significance to the involvement of the judge at the sentencing stage. I don't go back over those submissions that I made, in particular in support of my fifth broad submission, but there has been no attempt to answer or to grapple with any of the submissions that were made in opening, and it might be thought that that is the most significant feature of the submissions in response that you've heard. That was the only point I wish to make in response.
Could I just ask whether you can help us on the Kopinski?
Kopinski?
Yeah.
Yeah, I can try.
Because as Mr. Larkin pointed out, it seems that under the Hungarian law, where which was the law under which the gentleman was convicted,
yeah,
that there was a sort of pre-declaration, really, that either you might be sentenced to life imprisonment or with no license period, or that the license period could be imposed. So at the time of the offending, it seems that that was the relevant penalty regime that was in place. But when the court comes to deal with it, at paragraph 44, so this is page 13, it says the applicant complained that although the Hungarian courts had sentenced him to a reducible life sentence.
Oh, I'm sorry, I need to catch up.
I'm so sorry.
Sorry, paragraph
44.
44, yeah. Sorry.
It's just a slight oddity in the focus of the complaint and then the discussion that followed. The applicant complained that although the Hungarian courts had sentenced him to a reducible life sentence, the Ukrainian courts had converted that sentence into what turned out to be a de facto irreducible life sentence, which was a heavier penalty.
Right.
But for the purposes of Article 7, what you compare is the penalty imposed with the law, the penalty applicable at the time the criminal offence was committed. So at the time the criminal offence was committed, he was subject to a Hungarian regime which might or might not involve the possibility of licence.
Well, that's true. If one goes back to paragraph 24, you'll see the nature of the release on parole provision in the Hungarian law.
Yes.
47A1, and then you see 47A2 in that little bit in paragraph 24, which suggests that if the court doesn't exclude parole, it's then got a discretion to allow it, as it were, and it says 20 years. And then you go back to paragraph 6 of the judgment, and that shows that the Hungarian court concluded that it wasn't going to exclude parole, it was going to allow parole to operate, but after 20 years of imprisonment. And as I understand it, the complaint that then happens is that when he gets to Ukraine, that's all, as it were, thrown in the bin, and the Ukrainian courts say no possibility of parole at all.
But my question is, according to Hungarian law, the penalty could have been an irreducible life sentence.
It could have been.
And it just seems strange then at paragraph 44 that the comparison that's then being performed for the purposes of analysis under Article 7
is what they in fact did rather than what they could have done.
Did rather than what they could have done. I just wondered whether you're able to assist.
My Lord, I'm not really, other than it, to some extent it goes back to that question as to whether or not Utley in the House of Lords was picked up with in all its sternness when the case got to Strasbourg. Do you actually focus on whether or not on what it is that the court does, or do you focus on the maximum? And I don't want to reopen cans of worms from our perspective, because no one's doubted the House of Lords' decision in Utley, but one can see at least a potential problem under Article 7 if, for the sake of argument, you had an offence that was subject to a 20-year maximum as a determinate sentence, and a court sentenced them to 10 years, as it were, and then Parliament passed a law that says, no, it should be 15. One can see...
This point occurred to me earlier in the day, and I remember I went through some of the more recent Strasbourg authorities, and it is actually addressed in some of them. There are statements to the effect that Article 7 can apply either where a sentence is imposed which wasn't available at the time the offence was committed, or where a court has imposed a sentence and that sentence is subsequently altered by legislation or judicial interpretation.
Yes, in theory.
Yeah.
So one needs to be careful with the apparent rigour of Utley. And it may be that Kopinski is another example of this, where the focus for comparative purposes is on what the court in fact does. Here, the Hungarian court's imposing parole or saying there's a sentence with parole after 20 years.
Yes, it may have been Del Rio. I can't remember. It is addressed actually in one of the judgments.
Yes.
Right. I don't want to take up more time.
My Lord, I'm sorry, but that's...
I was slightly puzzled.
Yeah, but that's the best answer. They are undoubtedly focusing on what the courts in Hungary in fact did, i.e. parole after 20 years, rather than what they could have done, namely irreducible, because they undoubtedly could have imposed a whole life sentence.
Yes, it's really paragraph 8. Well, one of the places is if one's still in the same case, paragraph 50 of Kopinski, there's a citation from Del Rio Prada.
Okay.
89 and 90.
Yeah, and they say
may result in the redefinition or modification of the scope of penalty.
When that happens, in the next sentence, when that happens, the court considers that the measures concerned should fall within the scope of Article 7.1.
All right. Yeah. Thank you very much.
And that is even if there is a maximum that would have been available.
Yeah. So that's why we urge a bit of caution in relation to. I mean, no one's ever said Utley House of Lords is wrong, but the rigour on which it was actually decided is potentially problematic, particularly in the light of those passages. But I think that's the explanation of Kopinski. As I say, none of this touches the core point made about the fundamental distinction in a determinate sentence context between the determinate sentence and those things that go to the manner or execution of the penalty. Penalty equals determinate sentence. Well, also, those are my submissions in reply.
Thank you, Mr. James. Yes, Mr. McGleenan.
Lords, very briefly on a domestic law point, the court may anticipate this submission in the event, but we don't accept the proposition that there can be a freestanding appeal under Section 8 of the Criminal Appeal Northern Ireland Act 1980 in respect of the duration of the licence period or the custodial period. And we say that because the terms of Section 8, which are at electronic 782, are allowing a person to bring an appeal to the Court of Appeal against the sentence passed on his conviction. And we say that must be read with the operative provisions in the 2008 order, which are Article 7, 1 and 2, and Article 9.1, the provisions relating to sentencing, not Article 8, which is the provision that deals with the internal organisation of the execution of the sentence.
So where about 782? Sorry.
Page 782, my Lord, is Section 8 of the Criminal Appeal Act. And that has to be read with, we say, Articles 7 and 9 of the 2008 order.
And so somebody would be deprived of any remedy if something had gone wrong under Article 8.
Yes, it's not an appeal against.
Stay in prison.
Well, it's not an appeal against sentence, but you say.
I wonder if that's necessarily right. If something goes on in relation to early release, is there not a possibility of judicial review?
Yes, judicial review is the answer, not the appeal process, we say. And there isn't an example, no one's been able to point an example of an appeal under the statutory provisions in respect of an early release problem. And that's because there isn't an example, obviously, and also because there's a leave application for a criminal appeal pursuant to Section 10. So the Court of Appeal, presented with such an appeal, would be likely to indicate this isn't a proper appeal against sentence. If there's an issue there, you can take another course. So our point is not that there's no possible remedy, but there's no remedy in respect of this statutory provision. And we say that the KT authority that's relied upon in support of this proposition by my learned friend Mr. Larkin doesn't assist either on that point. KT, which my Lord Stevens gave the judgment in, and that's electronic 1838, is a director's reference to the Court of Appeal on the basis of an unduly lenient sentence. So it's not an appeal pursuant to Section 10, but it's instructive what the court did in that case. The court was dealing with an appeal in respect of a sentence. It wasn't dealing with an appeal in respect of the licence period or the custodial period, and that's apparent from the judgment of the court. You can see the conclusion that's reached is to be found on the key issue, page 1851, paragraph 63, by letter D. The court reaches the conclusion that they found the appropriate sentence in that case was a DCS of 3 years, having determined that the original sentence was unduly lenient. So the court dealt with the sentence issue. Then what it did in paragraph 64 and 65 is it put itself in the position of the trial judge dealing with the DCS, and by that process worked through the Article 8 algorithm that I took the court through earlier, applying the factors that are required by Article 8.5, and reached a judgment about a modification of the licence period. So the court wasn't allowing a freestanding appeal on the licence period itself. It was dealing with a similar but different appeal in respect of the lenience of a sentence. Having formed a different view, it followed necessarily on a DCS that the court then adjusts the elements appropriately. So there's nothing in here that's authority for the proposition that there is a freestanding route of appeal under this statutory regime against the internal components of the sentence. And we say that.
About a director's reference then? A director's reference. Say, for instance, a trial judge had extended the licence period to all but 1 day in circumstances where that was unduly lenient. Is the director restricted to judicial review?
It's not a point I've carefully considered, but I think judicial review would again be the appropriate route, because it's an issue about the organisation of the sentence pursuant to Article 8, and the director could bring an application before the divisional court.
There were two authorities cited in the KT case, and one of them, Summers, is a director's reference, partly on the basis that the sentence, in the strict sense, was unduly lenient, and also on the basis that the judge erred in the judge had failed to give reasons to justify the licence period selected. And the court did deal with it. It dealt first with the unduly lenient sentence and had to refix it, and then it explained as much that judges ought to be giving transparent reasons in relation to the licensing exercise, license period exercise, and they refixed it.
Lords, we say in respect of the argument is made in relation to Article 10 or Section 10 of the Act is in part that the Court of Appeal could have adjusted the sentence using these provisions. We say that's not a proper course in any event, because the basis on which the sentence would be being adjusted would be that it was a sentence that shouldn't have been passed, and that's not the issue in these cases. No one's saying, or should be saying, that the DCS sentence is the wrong sentence in this case. That is the facility that's available pursuant to Section 10, and that's not the issue that's actually engaged here. It goes back.
And at the end of the day, I mean, the question isn't whether the licensing period or the custodial period is part of the sentence for the purposes of Northern Irish law. We're concerned with the autonomous definition for the purposes of Article 7.
And that we only get into any of that if the court finds there's an issue with that gives rise to compatibility that leads to a different reading of Section 10 of the Criminal Appeal Act. We say, for the reasons Sir James has outlined, we don't get to that position in the first place. So that was the point I wanted to deal with in respect of that provision. We have, over the lunch adjournment, provided the court with the correspondence that was available to the court dealing with the habeas corpus application, which I don't intend to go through. Explains itself in terms of the interplay between the prison service and the court service on the issue of the warrant. Appended to the end of that correspondence are 3 additional warrants, which were later corrected. Again, they, in their language, do not refer to amending the sentence, but simply indicate an altered date of release. So those pieces of correspondence, we say, explain themselves and show how the committal warrants came to be.
Just on that, on the quick look, it didn't seem to. I think you had told us there was a letter from the Lord Chief Justice of the 17th of June.
No, I don't think there's a letter, my Lord. There's a position paper, and then there's or a memorandum, and then
there is, but that's a note to the Lord Chief Justice.
And then there's an email, I think, which I don't have it all in front of me, but which affirms that his position is per the recommendation, I think.
We don't, unless I'm missing it, we don't seem to have that.
The page 7, the Chief Justice has approved the approach.
Okay.
It's an email.
I'm so sorry.
I think there's something there reflecting the OLCJ's approval. Again, I'm slightly at a disadvantage. I don't have the copy.
Yep, thank you.
About page 7, I'm told. Of
yes,
that,
and indeed her email is below that, on the 15th of June.
Yep, thank you very much.
So those are our submissions in reply.
Thank you very much, Mr. Gleeman. Ms. MacDonald, it's your client who's in custody at the moment, isn't it?
Yes, Lord.
Mr. Lynch. And depending on the outcome of the appeal, he either serves another month or so, or he serves another 15 months. Is that right?
14 months.
14 months, yes.
April next year.
If we're in a position to give a decision now, would you rather would it be a good idea for us to do so at least he knows where he stands?
Yes, Lord.
Yeah, I thought so. Well, we'll adjourn and discuss the matter. We'd have to be very confident of our conclusion in order to do that before we start analysing the material on paper. But we'll adjourn to discuss it, and then we'll be back in just a few minutes. we're not in a position to give you our decision now. We'll have to take time to consider the arguments with some care. We see that the earliest date on which Mr. Lynch might be released, if the original order stood, is the 28th of March.
Yes, Lord.
So if we're in a position to give a decision before that date, parties will be notified and we'll hand down a decision, but probably not a judgment at that time.
I very much obliged.
So we're very grateful to Council for their submissions. We'll now try to produce a judgment as soon as we can.